Dear viewers, welcome to Doordarshan Kendra Kohima. Today we'll be having a talk on the topic, the Nagaland Moneylenders Act 2005. Three of us are from Kohima District Legal Services Authority. Before we go further, may I take this time to introduce our panelists for this afternoon. We have Mr. Joshua Sheqi, who is a practicing lawyer in the Gauhati High Court, Kohima bench, and also in the High Court Legal Services Authority. We are happy to have you, sir.
Thank you.
We have Mrs.Vimeno Nakhro, who is a lawyer in the trial court, Kohima District, and also a panel lawyer in the Kohima District Legal Services Authority. We are happy to have you. Now, to begin with, may I give a brief introduction on the topic. In what may well prove to be a landmark move to rein in the state, the Nagaland Moneylenders Act 2005 received the assent of the Governor on 28 September 2005 and published in the Nagaland Gazette Extraordinary dated 05/11/2005. It extends to the whole of the state of Nagaland. It has in total 29 sections in the Act. The Act seeks to provide necessary safeguards against exploitation of debtors and at the same time provide recognition to the moneylenders as a legal entity. And so, furthermore, as we go on with the discussion, we'll be hearing more in detail from our panelists. So to begin with, may I put this question to Mr. Joshua Sheqi to kindly highlight on what are the main objectives of the Nagaland Moneylenders Act 2005.
Actually, in the first place, I want to say thank you for having me here. This is actually a very important legislation that has been passed by the Nagaland State Legislative Assembly. Over the years, we have been seeing that we have this pawning system, some kind of the exchange of goods between the people, even in the olden days also, the barter system. But now with this modern time, the coming of the modern days has necessitated the state to also realize that Moneylenders Act has to be passed, because even now after passing this act, we're getting to see that a lot of debtors are under the control of the moneylenders. And I don't know how many people have actually registered under this. And of course, in the course of discussion, we'll get into the details. But then the very objective of passing this bill by the state, and now we have an act, is to see that our people realize the ugly side of money lending. For instance, if we look at the percentage, the highest that we see as of now in the state is it's 10%.
Okay.
But that is per month. And if we calculate per month, it is 120% per year. It's not a simple interest. And so the objective of passing this act by the state is to, as you have rightly mentioned in your opening introduction, to give a legal entity to these people so that they will get higher than the interest that is charged by the banks, where we have, because of the Article 371A, we have land which is owned only by the people. The state on its own does not own any property. It has to buy from the people. So that way, you know, the same thing also affects the entire system. Now that's why this act was introduced, to see that, you know, the system that we have in place is not actually favoring the people. Now that's why the act was introduced in such a way that the money lenders also will get more percentage higher than the bank interest rate. And then the debtors, as I've mentioned, because of Article 371A, now we do not have much pata lends. And then when you're going to when you're going to apply for loan in the banks and all, they insist upon the pata lends and all, which is owned by the government and is a recognized property. Even in Kohima also we are facing that problem. Seeing all this and taking all this into consideration, the state has passed this act. But though we are having a discussion on this topic today, as far as the effectiveness is concerned, I still have my doubts, because even the act itself also has some shallow areas, some undefined areas, which in the course of discussion, if you ask me, I would be happy to share.
Okay, okay. Thank you so much, sir. With the coming of this pandemic, now everybody and everywhere the systems are affected, more particularly financial sector is affected so much. And so this topic, the Money Lenders Act 2005, is a very crucial topic, and at this juncture again, financial status is very crucial, particularly in the state of Nagaland. And so as we go further, I would like to put this question to Mrs.Vimeno Nakhro, as rightly pointed out by our learned counsel, Mr. Joshua, in terms of the licensing and the authority power. And so can you please highlight to the viewers on what is all about license and power to suspend the license under the Money Lenders Act 2005?
Thank you, Ms. Sangtam, for the question. Well, this Money Lenders Act, as my colleague has rightly pointed out, and since the inception of this Money Lender Act 2005, every money lender, in order to lend money, he or she have to get a license. Now, in order to pertain that license, he could be anybody, but he should not be a government servant, but he should be a public servant ready to work for the people. Now, when a person wants to pertain a license for the money, for lending money, he or she should write an application to the licensing authority. Yeah. And after which, he also have to submit some charges to the licensing authority, and accordingly the licensing authority, they will go through it, and if they feel that if that person is applicable for issuing the license to that person, then that they will automatically give the license to that fellow, that whoever that person can be. And during that process, if the licensing authority, they feel that if that person is not applicable to get the license, then they will definitely, cancel the license. Okay. In the course, while cancelling the license, they will give the fee back to the fellow who have applied for the license. Now, again, if after applying for the license, if he or she feels that, or he wants to withdraw the particular license, then he can withdraw anytime, but the fee that he has paid while applying for the license, 10% will be deducted from that. Okay. And this license, after getting the license, every year he or she should renew the license. And accordingly, if he fails to renew the license, his license will be cancelled.
I see.
Yeah.
I see.
In fact, if I may be allowed to supplement.
Sure. Yeah.
Now, on the cancellation of license, the cancellation of license can also be when the person who has the license violates the terms and conditions.
Yeah.
Okay.
And now, in this area, I want to supplement for the fact that the licensing authority, the prescribed authority, is not defined in the Act. The Section 2 deals with, the definitions. In the definition, I'm sure some of the state authorities also may take note of this talk, or may not, because these days, with the coming of a lot of other facilities and all, people do not watch television as much as before, but I hope somebody will take note, because definition of the authority that will issue license is very important. I presume that, or I assume, that the cooperative society may be the appropriate authority to be issuing license, or the deputy commissioners of the district, that I do not know. But then the licensing authority, once they issue, now there will be a lot of terms and conditions for the money lender to actually follow.
Exactly.
Now, definitely we will be getting into the penal provisions also, but then if the money lender is charging more than the higher amount of rate that his interest that he is supposed to charge, or he is violating some of the terms and conditions, and then he is into, for instance, he is into buying some pound goods, or the kettles that has been pawned by some pawners. If it is not in an open auction, but he is going and then hidingly buying those from other pawners, then that can also amount to cancellation of license.
Sure.
Yeah, I want to supplement one more thing.
Sure, sure.
And if he violates any of the provisions in the Indian Penal Code, then definitely, automatically, his license will be cancelled.
Okay, okay.
It will be published also.
Okay.
Yeah, it will be published as well.
Now, what we understood in this very brief discussion is that the bottom line of this act is to obtain the license at the first place, the basic. Now, the act itself does not define the competent authority where to obtain the license. Furthermore, if we can hear from Mr. Joshua Sheqi also again on whether whether any offence that has been committed, as we have rightly said, like suspension of the license, so and so forth, any offence under the act is cognizable or non-cognizable, and also furthermore on the penal code as well.
In fact, only one section in this 29 sections act is a cognizable offence, that is the section 20, that is penalty for molestation of debtors. Now, if the money lender molests molestation, I think it is referred to mostly lady debtors and all, because we as a man, we hardly get molested. But then there, that is a cognizable offence. Though it is also a bailable offence, even a bailable offence can also be a cognizable offence. Although usually if we go to the Indian Penal Code, the cognizable offences are more serious in nature. And then many are non-bailable also. And non-cognizable offences are those which, without the permission of the magistrate, one cannot effect any arrest as such without warrant. So, in an offence like molestation of debtor, that is section 20 of the Act, once the complaint comes without the arrest warrant from the magistrate, also the police can directly arrest the person, and the punishment is up to 1 year. And as far as this act is concerned, it will have the section 20 will have an overriding effect on the Indian Penal Code.
I see, I see. Okay. Thank you so much, Mr. Joshua. Now, we also see in the Act, in this complete 29th section, there is a provision, section 12, where it talks about appointment of inspectors and their powers. When the Act is silent about the competent authority to issue the license, we also come across appointment of inspectors and their powers. So can Ms.Vimeno can kindly highlight on the provision of appointment of inspectors? Yeah.
Yeah. As stated earlier also, after the inception of this Act, the authority, as in the licensing authority. Now, after the inception of the licensing authority, once after this is granted, appointment of inspector has become a necessity, because the licensing authority, they will appoint the inspector according to their jurisdiction. Different jurisdictions will be given to any inspectors that have been appointed, and in some jurisdictions there can be more than one inspectors, 2-3 inspectors also, and the licensing authority, they can appoint any inspector. Now, after appointing the inspector, he has so many rights also, and as well as he has so many duties to perform also. For example, like if the inspector, if he feels that he have to check any moneylender, their documents, it could be their safety valves, or even their bank account. Now, what he have to do is, the inspector, he have to inform the magistrate concerned. Let's take an example of Kohima or Tungsang. In every district, we have 13 districts in our state, and in every district there is this judicial magistrate that is available. So the inspector have to inform the magistrate. Now the magistrate will accordingly issue a warrant, where the inspector will have the right to go and collect the documents. It could be books, anything, safety valves, documents, his account, and the inspector will bring it, and then he will check, and he can investigate. Now, after checking and investigating the whole thing, he have to, hand it over, the documents and everything, within 24 hours back to the moneylender, if he feels that if it's necessary to check. Now, even after which the inspector also, if he feels necessary, again that the investigation have to be carried on. Certain orders have to be pertained from the magistrate concerned of that particular district. Particular jurisdiction.
I see.
Yeah.
I see.
And that is why appointment of inspector is also very important while going through money lending business. Yeah.
In fact, the appointment of the inspector is necessary for the fact that they are there to assist the licensing authority, the competent authority, to see that the money lenders are actually functioning within the purview of law.
I see, I see.
And so that is why the role of the inspectors, as my learned friend has already mentioned, it's very important. And then they are not there only to find faults, but also to give a detailed account of how the money lender is running his business. So that will also determine on whether the license will be extended year-wise. And that report will also be important to either continue or cancel or even put up a complaint, a detailed report that will lead to the arrest and then a conviction of the money lender also. And that is covered by Section 18 of the Act. So, for instance, a money lender is not keeping proper records. If his problem is with record maintenance and all, and then there is every possibility that he has cheated the borrowers, then simple imprisonment up to 6 months is the mildest punishment.
I see.
And then, for instance, a money lender is he is lending higher than the percent that he is supposed to charge, that is not more than 3% above the normal bank interest rate. Then the money lender can be punished for a period extendable up to 1 year. And then, for instance, he is either charging more percentage than the bank interest, or he is giving lesser money, and then the borrower has received lesser money, but then the record shows otherwise. That will also amount to penalty of a punishment up to 1 year imprisonment, or 5,000 rupees fine, or both.
Okay. Okay. Yeah. Can we also hear from Mr. Joshua again on very specifically on the interest rate or interest charges allowed by the Money Lenders Act, and also the penalties and the jurisdiction to try the offences as far as our state is concerned? After all, this act is for the state of Nagaland particularly. And so very specifically, if we can highlight to the viewers that on the interest rate charge under the Money Lenders Act very specifically, and also the penalties and the jurisdiction to try the offences.
Yeah, of course. The first one was
the interest rate as per the Money Lenders Act. Yes.
In fact, I am repeating myself, but it should not be more than 3% more than the bank rates.
I see.
And the bank rates of interest can also vary from time to time. But then, for instance, an agreement has been entered between the money lender and the borrower. On the day the money is given out, it will be recorded. They have to maintain a proper register. Records will have to be maintained. So the agreed percentage, for instance, the highest bank interest, definitely a money lender who is registered will go and look for banks. Also, they give interest in terms of their policies and all, and some banks they offer higher interest.
Yes, true.
So the money lender will surely go for the highest interest,
True.
and then from there he will put another 3% additional interest. Now, what our Naga people have failed to understand is, some are giving by 10%, and some are saying, we give at a lower interest, the 5%, even 5%, 5 into 12, that is 60%, 60% per annum. As far as the Act is concerned, the interest has to be charged annually, that is
Okay.
year-wise,
Okay.
not monthly.
Okay.
So 5%, are Amikhan Khali 5% he charged Kurishe. That's how people come to say, we charge only 5%, why they are complaining? Are 5%, we are not talking about a monthly interest, it has to be calculated annually. So yearly it's coming to 60%. That's why when the matters come before the court of law, they get the beating. And then if we go to section 24, that is no person who does not have the money lender's license from the competent authority. Yes, we have already mentioned who is the competent authority. Definitely the state already has some authority which is not mentioned in the act.
Yeah.
And just because it is not mentioned in the act does not mean that the law is redundant and cannot be used. I believe it is either the Registrar of Societies office or the DC office. But now, if a person is is lending money without the license, one can be imprisoned up to 6 months.
Okay.
And for instance, the person, if the inspector is supposed to check everywhere. He is not only to check the persons who have the license to give out money, to the borrowers. He is also to check, and then he is supposed to inquire about the information from here and there to see if anyone is illegally lending money. That is the job of the inspector. And the inspector, once he gets caught of such person who is lending money, the first, as I've said, the simple imprisonment up to 6 months.
6 months, yeah.
And then if he also finds out the record that the person is charging higher than the prescribed percentage that is prescribed by law, then the person can be punished. In addition to 6 months, he can be punished up with that additional 1 year punishment also. And that is what our local people are yet to understand. We have a few money lending cases in the court also, in our district courts. And then our people are yet to understand. So while talking about this, I would also want to request the state machineries to, trickle this information down to the village level also, educate the village level leaders also. If not, the law is already there and people will be punished out of their ignorance. And of course, as far as the principle of law is concerned, ignorance of law is not an excuse. But when the state machineries do not take that play that proactive role to educate the people, especially the simple folks. To be very honest, we're all Nagas, and then our viewers, I believe, will only be Nagas. We came out of nakedness only yesterday. Our mind is still very innocent. And so it's a fact. From nakedness, we jumped into this modern world. And that's why, the grassroots level education is very important. And as far as the jurisdiction of the court is concerned, my learned friend, Mrs.Vimeno has already mentioned, but it is the court with jurisdiction. And now, as far as the act is concerned, even if the offense be punishable up to 6 months or up to 1 year, because the maximum punishment is 1 year, but the same cannot be tried by a second-class magistrate. It has to be a first-class magistrate to try the offenses under the Nagaland Money Lenders Act 2005.
Okay. Thank you so much. We are discovering more and more of the act, which is very incomplete, I would rather say, but always there is always good news that the provision is there for amendment as well.
Exactly.
So I'm sure the government or the high level of the government will take into note of the provision that is available in the act for amendment especially. Now, as we come to the closing of this talk, can we hear from both of you very precisely on how far the state of Nagaland is effective in implementing the Money Lenders Act 2005 in practical? Of course, from the beginning, we have been discussing on the provisions that is available there, and of course, the other side of the act we are also talking. But in general, practically, what do we see in our own kitchen, in our own villages or in our own town, how people are doing, how much rate people are asking, be it 15%, be it 20% monthly rather. So can you please highlight in a precisely on the implementing part of this Act 2005.
I would like to hear from Madam Vimeno first.
Well, as my learned friend have already mentioned, Mr. Sheqi, that implementing of this Moneylenders Act still in many remote places, we are yet to cover. Many people are still, many lenders, they don't even have license. And on top of that, they charge high rate of interest. And many of our people are also ignorant. Now, at this juncture, today, I would like to appeal to my people, that is the citizen of Nagaland. This Moneylender Act, this was introduced to protect the borrowers, especially to protect us, in order to save us, protect us. So, if any citizens in our state, if they are yet to know about this act, we are always there to help you. And there are DLSS, that is the District Legal Services Authority, in all the 13 districts, headed by chairman and secretary. So at any time, if any villages or if any community, or it could be any ward colonies, it could be anything, if they feel that they have to know more about this act, we are always ready to go and serve our purpose. I am also a member of the team of DLSA Kohima. In Kohima, we have 33 villages, covered by 33 villages, from Tsiminyu till Zubza to Kidima, that side. Now, what we do is, we try our level best to go and cover the villages where any awareness, it could be this pertaining to this Moneylenders Act, or it could be any other act, that if they feel necessary, we go and give effort, free education, we give them free education, free legal awareness. Now, so at any cost of time, if our people, if they feel, it could be from any districts, from the 13 districts, if they feel necessary, we are always ready to go and share more about our Moneylenders Act also. Because mentioned earlier, I'm repeating again, but in many of our districts, we are still not implementing this Moneylenders Act, and I feel very sorry, because this act, this was introduced so that we could utilize it, but because of our ignorance, specifically because of our ignorance, and our people, especially our Naga people, were very laid back when it comes to law and functioning. So as this has been introduced, it is my appeal to our people that we should utilize it. Yeah.
The first point I would like to make is, since we are almost coming to the conclusion, as our host has already mentioned, is that our people have this misconception of the modern laws. The customary courts do not have a jurisdiction to try the Moneylenders Act. That is the first message that I'm putting across, because that's a fact, that's the law. And the same issue has become a settled position of law, because the High Court has also passed several judgments where it says that any issue that has got nothing to do with customary law, the customary courts cannot adjudicate upon. And so even the Moneylenders Act, also the village customary courts or the Dabashi courts, they have no jurisdiction to try. I do not know, and I have not heard, and I have not met even a single person who is said to have registered himself under the Moneylenders Act. So I don't know if we have even a single person, and if I'm wrong, the viewers may kindly forgive me. And if anyone has registered under this act, I say congratulations to you, because I do not know anyone as such. Now, the state has to implement this on a war footing. If it is not implemented on a war footing, then we do not see a future of this act. The law is in place, but I don't see the future of this act. Now, coming to conclude, I would like to mention something about the pawn broker and the pawner. See, the pawn broker is also a person who has the license of a money lender. Now, for instance, a person does not have money to pay back. So it is almost as the pawner is almost like a mortgager. So he will mortgage, or he will pawn his goods or kettles. And now, for instance, if the person is offering that, then again there will be prescribed form where the pawn broker, who is the lender, the pawn broker will issue a ticket. Once they come to an agreement, and that is the ticket is up to the borrower on whether he will, the debtor is the borrower,
Okay.
Whether he will accept or not, that is up to him. But then once that is accepted, now it has to be completed as far as the law is concerned. The whole process of paying back has to be completed within a period of 1 year. But if there is an agreement where it says more than 1 year, 7 days grace period after the period is over, 7 days grace period will be given.
I see.
And then that is the pawn broker and the pawner is mostly to do with exchange of properties.
I see.
And now, for instance, after that is closed, the pawn goods or the kettles will be put to public auction. And in a public auction, if the proceeding of such proceeding has amassed more than what is
Okay.
due to the money lender or the pawn broker, the inspector will also inspect those documents and then will pay back
Okay.
the additional amount to the borrower, the debtor. So that is basically that is the provision of law. But I want to repeat myself with the last sentence again to appeal to the state that this Money Lenders Act is a beautiful law, but the same has not been successfully implemented thus far because the legal services authorities are also trying, but our people will understand only when they are put to jail. And so far, I do not know even a single Naga person who is charging exorbitant rates of interest, which is not permissible by law, has been put to jail. And that's why the state machineries, I say, are failing very pathetically. And I wish the state machineries will take note of this appeal and take stringent steps upon those people who are openly charging up to 60% or 120% or even more in a year. And that is not permissible anywhere in the world. Even before the Money Lenders Act came into being, we have the Usurious Loan Act of 1918, which talks about a percentage to be charged from the people. Right now we have this Money Lenders Act with us, which is much higher than the Usurious Loan Act percentage that would be permissible in law. That's why we have to make use of this, and the state must approach this and then educate our people in a war footing and then even punish the wrongdoers. Then this law will see the light of day.
Yeah. Thank you so much. We have a very good learned counsels here to highlight about the Act, and we are so thankful to both of you. Just to conclude with a note, after hearing about the Nagaland Money Lenders Act 2005, this is an act for regulating grey business which has left many buried neck deep in debt. However, with the coming of this act, several provisions as mentioned, such as the interest rate specifying specifically appointing government inspectors to scrutinize the account books of money lenders, obtaining annual license and bound ticket, and most importantly, legitimizing the trade are identified in the Act. So, dear citizens and viewers, let us be watchful, let us be vigilant and consider this Act as a very important tool. Thank you so much, our panelists today, for your valuable inputs. We acknowledge and appreciate your efforts in disseminating such information to the citizens of Nagaland. Thank you.
Thank you so much.